The only other thing I would put on the record is I understand Mr. Macias is practicing under a supervised bar card, and he was gracious enough to send us that letter. Ms. Luna was the same, and I looked up the rules about what they can do, and some judges didn't think she was able to do. It is from the state bar, and it says that you must be practicing under a supervised attorney, but they actually list Ryan Free. So supervising attorneys, and it says Ryan Free. And that's the only attorney that the state bar lists can be supervising him.
It can be supervising Alex.
On his supervised status letter from the state bar.
He's another chief judge.
So we looked at this heavily. We had a long conversation with Judge Wright. There is a provision for remote, just to be completely candid, for remote supervision. And I actually called the state bar about that. And Miss Luna was in here trying to obtain a reset. I was across the hall, and they said there's no problem with that. And she can contact you by text. She can call you. It's not a hearing. So that was remote supervision. But for me to not sit with her during a trial, you can't remotely supervise them throughout the entire trial. They'd have to be on the phone with you the whole time.
So you're objecting to his presence then?
Yes.
So
I don't think it allows for him to try a case. Just going by the letter, it says specifically Ryan Free. It's the only attorney listed as the supervising attorney.
So Floyd, can you do me a favor? The statute that allows Alex to practice under a supervised attorney, does the wording state that as long as there is a supervising attorney, or is it only the person that signed their bar card?
Show me what you have so I can see it.
Yes, sir.
It's not a statute. It's in the
Yes. My apologies. Yes.
I think if it said the Harris County DA's office, it would have been.
And with respect to everyone here, and I don't mean to, it also have to be someone that's been practicing for at least 3 years to supervise him.
Do you want me to email this to all the parties?
Yeah, or show me what you're referencing.
These are called the rules governing the supervised practice of law by qualified law students and qualified unlicensed law students, law school graduates in Texas. And then if you go to rule.
Alex, are you still in law school now?
Yes, Your Honor.
What year are you?
A third year.
The supervising attorney has to be an active member of the State Bar of Texas in good standing who has practiced law in Texas for at least 3 years. And so.
Has he not practiced law?
I have no,
And
and that's what I was asking if he.
How long have you been
No,
practicing?
2, Judge, but I'm just reading some of the rule. One moment.
Yeah, there's a duty to immediately notify the state bar membership department if the lawyer no longer meets those requirements of these rules.
Do you want to reach out to Beetle and see what he says real
Can you
quick?
give me one moment, Judge?
Of course, take your time. Just not too long because we get the jury, but yes.
Good morning, Officer Squash.
Good morning.
Can you please state your name for the record?
My name is Officer Brooke Squash.
And Officer Squash, what is your occupation?
I'm a police officer.
And are you a certified police officer in the state of Texas?
I am.
And how long have you worked with Deer Park as a police officer?
Currently almost 6 years.
So when you first began this investigation, what was the date of the offense?
Can I refer to my report?
Yes, officer.
The date of the offense was March 7th, 2024.
Okay. And was that investigation prompted by a call from dispatch?
Yes, it was.
And what information did dispatch provide?
Dispatch relayed that a couple, a male and a female, were driving a motor vehicle in the Sonic area. They had come to the drive-through and were trying to order alcohol through the drive-through and had struck a portion of the building with their vehicle.
Pay very close attention to what happens next, because this is where the investigation starts connecting the vehicle to the defendant. The officer runs the plate, finds the registered owner, and then goes directly to that person's address. But there is already a major question hanging over everything. The original caller said there were 2 people in the vehicle, and the officer never actually saw anyone behind the wheel. So before we go any further, I want to know what you think. Is that enough to identify the driver, or is the officer making a leap based on circumstances?
They also provided a license plate.
And was the call about a possible intoxicated driver?
The call initially came out as a possible intoxicated driver, but the caller was giving information regarding failed to stop and give information for a possible accident as well.
So, officer, what are the first steps in an investigation when you receive this information from dispatch?
The first step was to run the license plate to see if we could figure out who the vehicle belonged to or where the vehicle's registered owner was.
And officer, what information did you obtain when you ran the license plate?
After running the license plate, I was able to determine that the owner was a defendant who I've come into contact with before. I additionally was able to observe the address of the registered
Your
owner.
Honor, I would object just to relevance on what the officer just testified to.
State your question.
Just what information did she obtain when she ran the license plate? And if you could continue, you were talking about the address. What information did you obtain when you were talking about the address?
Sure. I was able to observe the address of the defendant and noted it to be a place that I had been before.
Objection, Your Honor. May we approach?
During direct examination,
Madam Officer, my only concern is this case. I don't want you to get into anything about any kind of prior knowledge, prior context, anything of this nature, please. Anything, this case, it only resolves what you saw, what you encountered here, that's it. Okay?
I'd move for mistrial.
Okay, let's deny it. You know, I don't think that it rises to the point where it's that kind of error that it would require mistrial. But like I said, if you'd like to, I could admonish the jury not to.
It would do more
you know.
damage to address it with the jury, so I'm not gonna ask them.
But I mean, I'm gonna admonish you, if you get into stuff like that, I will. So no, anything about any kind of prior context, whatever, just, okay?
You said you obtained the address, the registered address of the vehicle. Did you go to that address?
Yes,
As you're going to that address, did you observe a vehicle heading to that address?
yes,
Did you observe the vehicle turn into the driveway?
yes,
Were you able to observe the driver exit the vehicle?
I was able to observe the driver at the driver's side door coming up, but I never saw anybody behind the wheel.
And officer, when you approached the address, was the vehicle still running?
No,
Was the vehicle turning off?
yes, the brake lights were still illuminated as if the vehicle was turning off and, you know, everything was shutting down.
Were you able to see the vehicle pull into the driveway?
Yes, I observed the vehicle pull into the driveway.
The driver, were you able to make contact with the driver?
I was,
Is the driver in the courtroom today?
yes,
Can you
Your
identify?
Honor, I object. That calls for speculation. The witness testified she never saw anybody behind the wheel.
Your Honor, she says she observed the driver, the person outside the driver's side, and she can state why she believes the person to be the driver.
No.
I can-
Did she see him driving?
And I can ask additional predicate questions.
See if you can, did she see that, who was driving?
That question has been asked exactly in that clear manner. And she stated, no, I never saw anybody behind the wheel. She said she saw a man out in the driveway and the car was off.
She didn't see him drive?
Officer, is it your opinion that the person you observed was driving?
Objection, that is leading and that calls for speculation. She's already answered that she did not see anybody driving.
Same.
Officer, did you form an opinion as to who the driver was?
yes,
And what was that opinion based on?
Objection, this calls for speculation, Your Honor.
How?
there anyone else in the vehicle when you observed it?
No, there was not.
And what was the time period between when the vehicle pulled in the driveway and when you observed the person outside the driver's side?
Seconds.
And did you confirm this was the same person the vehicle was registered to?
I did.
Did the person have the keys to the vehicle?
I don't remember.
And based on those observations, did you form an opinion as to who was driving?
I did.
And who was the driver of the vehicle?
Objection, that calls for speculation. She already said.
Sustained.
Thank you.
When you spoke to the driver, where did you make contact with the driver?
Objection, now this is objection to relevance now because we've established she can't identify who the driver was. So any questions about what happened to the driver, she can't identify the driver. So I object to relevance. The question was, what did you do with the driver? She didn't identify, she didn't see this person driving.
She has laid the groundwork through circumstantial evidence as to how she formed her opinion as to who was the driver.
This is not a circumstantial game. It's not. And I'm sorry, Mr. Free, you know. You wanted to say something?
I'd like to move to suppress the detention for it being illegal and just recite what we know so far. The 911 caller from Sonic stated that they did not give any physical description of who was driving, stated that there was a man and a woman in this vehicle, stated that there was, that they damaged their mirror by running into the drive-through, and they turned left out of the restaurant. Officers, well, she didn't say it yet, but she went the other direction, and she even, they state that so they ran the license plate, and on a hunch, they went to, here's kind of the full story, that she did have previous encounters with him, and she said on a hunch, when they saw that plate came back to him, they went directly to where they know he lives. And they wrote in the probable cause affidavit, they saw him exiting the vehicle, which is not true. And there's an interview with the state, with Alex, where he talks to both of the officers, and they both say, no, we did not see him exiting the vehicle. So we have that problem of no identification whatsoever. She couldn't identify him in court from the Sonic call, but then they go to his house and
Into his house?
they go straight to his house. They don't even go the direction the Sonic person said that the vehicle left. They go westbound. The vehicle was reported to have gone eastbound. She drives over to his house because there's history, and he said that they've been to his house before. They mess with him. They mess with people that are over there. That's kind of, they knew him. But she wrote that in the
hearing right now.
No.
she wrote that in the probable cause affidavit too, that she has encountered him before and she knew him to be an intoxicated driver, for what it's worth. She wrote that in the PC affidavit. That's why she went to his house when she got the name. But she said, I never saw anybody behind the wheel. There was only one person in the vehicle, and the reportee said there were two. They were able to, never saw anyone behind the wheel, observed a vehicle. Oh, was there anyone in the vehicle when you approached? She said no. She said it was off, and then asked if he had keys to the vehicle. She said, I can't remember. No identification of him. Oh, and here's the other piece of information that is really important. If there was going to be some other evidence that he was operating, or that was the truck, look for the damage on the mirror. They do that.
My only concern
There's
now.
no damage though.
Concern now. Do we have a witness that sees him driving?
I mean, obviously, that's a lot to respond to. I'll just take it about the issue that's at hand, right? Wheeling the defendant, okay?
I don't care about all the extraneous crap. I don't care. My only issue now, because really,
I'll let you the judge. We're relying on the basic premise that the law does not require absolutely a person watching the person behind the wheel. They can still be wheeled, legally speaking, sufficiently through other means, both through an admission, their own admission, and then through other circumstantial evidence. We're getting in both the admission of the defendant who admits to
But you
driving.
can't get to the admission.
That's what I'm saying, is we've got to lay the groundwork there in order to get the officer, let the officer testify to all of what she saw, all of the things that Tyler's bringing up. Some of them are partial truths, and maybe they're worthy of being impeached on. Maybe, maybe not. We're going to let her testify. The jury should be allowed to hear her testify and decide what is credible and what's not. She's going to testify to what she saw, and she's going to make it very clear there's literally no one else that could have been driving the car. There's just not. Same thing as if a person comes on an accident in the middle of the road. In the
There's
middle of
still a
nowhere, there's
hunch.
no one there.
It's a hunch. Sure.
She's going to testify that she watches the car drive up into the driveway. She's going to testify to you that she watches a male get out of the vehicle. She's going to testify that she doesn't lose visual contact with that person. She's going to testify that she watches the brake lights go off. She's going to testify that this woman that was talked about is there. She's on scene. Tyler's aware of this. I know he's aware. He's read the OR. She's sitting on the porch of the house, right? So she's going to, if given the chance, she's going to testify to all of this. This will lay the groundwork to get in at least her body cam when she speaks to the defendant, and you can hear from him himself about what he was and wasn't doing. He'll make plenty of statements on that.
You said there could be nobody else possibly driving, and now you're saying that there's another woman at the scene.
Already there when the car pulls up, Tyler. She's on the porch.
Not according to the Sonic people, though. She said that there were two people in the car.
I understand
Didn't
that.
give any physical description. Could not identify him in the courtroom after 7 times asking.
So listen, the Sonic is why the
Judge,
officers
just-
begin, I'm not finished. The Sonic is why the
There is no
officers begin
witness that can say
investigating.
they saw him driving.
You can't talk when he's talking. I can only take one.
Tyler,
I'm sorry.
let him finish.
Sonic is why the officers initially investigate the defendant. That's clear, right? There's the 911 call, even though she was unable to state that she recognized the person in the vehicle on the record. She calls 911, she gives a description, she gives the license plate of the vehicle that she saw with the person driving and that ran into the Sonic. Police get the dispatch, they run the license plate, they recognize the person. They go to that person's residence.
And there's the problem.
Why?
They recognize and they assume who that person is. There's two people in the car. They're making an assumption.
She said that there was the witness just said there was a male, an older white male driving.
Your Honor, if I may, the 911 call does not identify who's driving. So she doesn't know who's driving when she gets dispatched. She doesn't know if a man or a woman's driving. If we listen to the 911 call, she just says there was a man and a woman in a vehicle.
And she writes on a hunch.
I don't think it survives a directed verdict. I don't.
I don't want to waste the court's time, Judge. We're going to get testimony from the officer about all of the circumstances of what she did and didn't see. She's not going to testify that she saw this defendant specifically behind the door.
I don't
She's
think
not
it's
going to.
relevant.
Okay, so then is it the court's position then that based on the testimony and your rulings on the evidence thus far that you wouldn't allow in the remainder of the testimony such as body worn camera? Okay, then I'll follow.
Sorry.
I'll dismiss.
Yes, Your Honor.
All right. That's it.
So a motion to suppress the detention.
Thank you, Your Honor.